Today, we're going to discuss real defenses versus personal defenses. What is a defense? A defense is something you can validly raise when it's an issue by the maker or the issuer, when they don't want to pay, to refuse payment because of these valid issues that could be raised. If we're talking about real defenses, it is the issues you could raise against a holder in due course. While in a personal defense, these are the issues available against an immediate party, or meaning it's the or an immediate party or a remote party, so it's privy was the knowledge of this infirmity or defect of title of the one endorsing the promissory note, as long as it is not a holder in due course. Question: why this real and personal defenses can be raised by a maker or a door? Of course, this is to stop payment because there are valid issues. There are why the question and second question is why the holder in due course is always protected, meaning there is a priority or to claim, because this is the protection given to the holder in due course to make the promissory note or the negotiable instrument to be able to pass it to parties, to the next party, so on and so forth, until they decided to make payment. Again who is a holder in due course? A holder in due course is the one who acquires the promissory note with no defects, in good faith, of infirmity of the promissory itself, and the title, who is the one endorsing. Okay. First, we go to real defenses. In the list of the real defenses that could be raised against a holder in due course are 1. Prescription, 2. Material alteration, 3. Illegality, if declared void for any purpose, 4. Duress amounting to perjury, 5. Want of authority of agent, 6. Insanity, where the insane person is a guardian appointed by the court, 7. Fraud in the factum or easy contracts or fraud in execution, 8. Non-delivery of incomplete instrument, 9. Minority, 10. Ultra vires act of the corporation, 11. Discharge in insolvency, 12. Forgery, 13. Execution of instrument between public enemies, and 14. Marriage in the case of a wife. So, these are real defenses that could be raised against a holder in due course. Okay. We go now to personal defenses. There are the list of personal defenses which could be raised only to immediate parties privy to the infirmities of the promissory note or the title by the endorser, or even remote parties, not a holder in due course, who are privy to the fact that the promissory note had infirmity. Okay. 1. Non-delivery of complete instrument. If the complete instrument is not delivered, then it is one of the personal defenses. Meaning you have to prove, the one raising the issue should prove that there was no delivery of a complete instrument. Otherwise, the maker or the issuer is liable to pay. Number 2, ultra various acts of corporation. When the corporation has the power to issue negotiable paper, but the issuance was not authorized for the particular purpose it was issued. So an ultra various act, it go beyond the authority of the corporation. Number 3, negotiation in the breach of faith. Number 4, insertion of wrong date in an instrument. Number 5, conditional delivery of a complete instrument. Number 6, filling up of the blank in instrument wanting in any material of particular beyond reasonable time. So, beyond reasonable time. Absence of failure of consideration, whether partial or total. 8, illegal consideration. 9, filling up the blanks in an instrument not within the authority. Meaning you had go beyond the tenor of the agreement of filling up the blanks. If there's just, the agreement is just 5,000 and you put 10,000, then that's it. Want of authoritative agent where he has apparent authority. Lacking of authority of an agent. Fraud and inducement. Acquisition by force, duress, or fear. So meaning there was no delivery. It was just that the payee or the transferee acquired the promissory note either by force, hinold up, duress, pinilit, ninakaw, napulot, pinagkatiwala, nanloko. That is the acquisition by force, duress, or fear. Intoxication. The promissory note was issued when he was intoxicated, or there was a mistake. Insanity, or there's a notice in the part of the contract with the insane person. Negotiation under constant amount to fraud. Acquisition of the instrument by unlawful means like blackmail or illegal consideration. If we're talking about real differences, the instrument is genuine and all respect its purpose to be. Real differences, one of these real differences are material alteration, perjury, juries amounting to perjury. Want of delivery of incomplete instrument. In a real defense, if the instrument is incomplete and there is no delivery, that is a real defense. An issuer could raise against a holder in due course. But if the promissory note is complete and the issue is non-delivery, it is just a personal defense. Why? Because, as I have said, a negotiable instrument is the main purpose is to be negotiated. So you don't put doubt to that. If there is any doubt, you have to prove it. You have to go to court. If you had a blank check if you have a blank check and the said blank check was stolen, or not only stolen, there was a robbery, you have to inform immediately your bank, your drawing bank, that there was a crime that happened, to secure your finances, to call your money. Because otherwise, if you just make it a report a day after or 2 days after, then there was already some payee or endorser that had been there was already scammed or by other parties who have acquired the non-delivered check. So, reiterating again, the difference between real defense and personal defense is that you have to remember the definition of a holder in due course. The holder in due course is the one who acquired the promissory note or the bill of exchange with no defect, in good faith, with no infirmity, there is no erasure that can be noticeable, or the one who endorsed had no outward signs that there was illegality in the endorsement. So that's a holder in due course. Meaning, a holder in due course have given priority, given more right to collect. This is in protection of the functions of the negotiable instrument, that it can be easily negotiated because everybody is required to pay when this promissory note comes into the hand of the holder in due course. So that's why these real and personal defenses are given. In the personal defenses, you can only raise that, like say for example, A is the issuer and B is the secretary who who take advantage of this check. So you can go right there to the immediate parties, immediate adjacent or privy. Then this let's say for example, the secretary had negotiated it to his mother. So that's again, although it's a remote party, but the mother should have known that the secretary had just acquired this from the employer. So they are in private, or in remote. They are remote parties. Still, they have this. The issuer can raise that issue not to pay or to stop the payment for any immediate and remote parties. So much for that.